Good morning, everybody. Apologies for the late start. We were just having some technical issues. Welcome to everybody for today's legal perspective, a year in view, what's happened and what to expect for the future. Our running time today is 1 hour. We do expect to keep it to just before midday. We will have questions towards the end of the session, so please do pop your questions into the chat area. I'm pleased to announce we have two speakers today. We have Chris Green, who is a partner with Kyo's. Chris provides specialist support and advice following accidents, crisis events such as food, fire, rail and environmental accidents for his clients. He has many years of experience, and he's also joined by Phil Pennington, who has 16 years of health and safety experience, and Phil is our audit and consultancy manager at the British Safety Council. Unfortunately, we're having a couple of technical issues with Chris's camera today, so you will have Phil on camera, but Chris will be voice only. Apologies for that, but we should be able to run the webinar as normal. So over to you now, Phil.
Okay, thanks, Elaine, and welcome again. Thanks for attending this morning. We've titled this a review of the last year and a preview of what's to come. What I'm pleased to say is we're not going to be focusing on COVID. I think we're all sort of COVID management fatigued out over the last 2 years. We are going to touch on a few issues that have arisen because of sort of, if you like, a spin-off from COVID. But there are some emerging issues there that we're going to do. We had chosen to set this webinar up as a conversational piece, and hopefully Chris will be able to join us shortly, barring any solution to his technical problems. And we're going to do it from a conversational piece because we felt that actually trying to present in a situation like this was not really going to be beneficial to anybody, because as we know, there hasn't really been a huge amount going on from a legal perspective, but there's been quite a few things happening from the courts. And when Chris joins us, we'll talk a little bit about where the courts are going and what prosecutions are looking like. Whilst we're waiting for Chris, one of the things that Chris and I discussed only the other day, which I thought was quite pertinent, was the impact of prosecutions, not directly, not the court case necessarily, but the reputational impact. We've seen a lot of companies during the last, well, I suppose 6-7 years, with corporate manslaughter and the guidance coming out, finding it really difficult to operate because of the financial implications of being under investigation. Now, obviously, we all know as practitioners that our aim is to avoid accidents and incidents happening, and none of us want to be in a position where we're having to investigate a serious accident or, you know, a disability that one of our employees has had. So we're looking at what the reputational damage is, and many boards are now looking at where their reputational risks are. And obviously a lot of business risk registers would look at reputation naturally. In the instance of health and safety prosecutions or investigations even, there are reputational damages, and from my own experience, working in a number of different industries, that reputational damage goes quite deep. You can, for example, find that if you're under investigation for a breach, it's quite possible that your suppliers will be aware of this, and they'll be concerned because they know the prosecution risks, and they know that obviously you can't insure against those fines that could come through. So your bottom line is going to be potentially impacted by what goes on. So I've had conversations with suppliers for companies who basically thought, well, actually, should I be extending my line of credit with these companies? Should I actually restrict it from 3 months to 2 months? That has a knock-on effect to a business's ability to trade. That, alongside the concerns that employees have, whether they want to be connected with a company who potentially could have serious impacts to know how they're going to be employed in the future. So staff retention becomes a problem. Recruiting new staff becomes a problem because word gets out. We're lucky enough to work with an organisation whose one of my colleagues had a partner who worked for a local authority, and that local authority had just been prosecuted. Now, she went in there to join it, but actually she was in a position where she may have been connected with that organisation when in fact she had nothing to do with what went on. So people would become a little bit less enthusiastic about joining organisations if they're in a position where there could be potential prosecution. Chris, I think you're now with us. Is that right?
I hope so, Phil. Can you hear me okay?
Oh, yes, we got connected.
Fantastic. So sorry about the technical glitches.
No, that's fine. I'm glad you're able to join us anyway. Obviously, we just touched on the reputational damage stuff that you and I discussed the other day, and just explained that we're going to do this on a conversational point. So firstly, obviously the key bit from your perspective, as someone who sees the insides of courtrooms more often than hopefully many of us on this call, what's the sort of thing that you're seeing in health and safety prosecutions?
It's really twofold. I think you're right. We'll touch in a moment when we're on the fines and how that's actually changed as a result of COVID and since the pandemic. But it's the indirect consequences and its reputation, its share price, it's the risk to the individuals. And these are the key messages really that we try to get out, isn't it, to boards, so that without scaring them more than we need to, they are actually aware of this before that dreaded day where you have an accident in the workplace. So for those reasons, I think you're right, reputation is key. If I were to just throw out the letters P and O at this moment, instantly I'm afraid the media reports just evoke a certain image, and that is more powerful when I'm going around directors perhaps even than the level of fine. But as I said, we'll come on in a moment to some of the figures, and there's some fairly eye-watering amounts as well. So we need really just to be balanced on this. I think what COVID gave boards that didn't understand previously was an insight into how important safety practitioners are, the need to ensure that they actually had enough of a workforce to carry on working. But I'm afraid my experience is that regulators sometimes have fairly short memories. So it may well be that certain sectors haven't even traded for 2 years. Well, if they have an accident now, I'm afraid we're seeing very little discretion given to some of the big operators, and they're going to be treated in exactly the same way with all of the turnover-based fines that we've already seen. So the short answer to your question, I think, is yes, the fines are increasing, but the PR and the media and the reputational risk, I think, is higher than ever.
Yeah, I think you're right. I think that, as you quite rightly said, I mean, the P&O fiasco was probably, for most of us, brought us into focus on the damage that can happen. And obviously, historically, those of us are old enough to remember the Herald of Free Enterprise, remember the damage that was done to reputation for P&O back in those days. I think the other thing, I guess, really, Chris, is COVID caused a pretty significant backlog in the court system. So, you know, there's a lot of cases, general criminal cases, that are taking a while to get to court. From the HSE perspective, I guess, really, what's happening in relation to prosecutions that have been ongoing? Because I know we've seen cases that take 4 or 5 years to get to court, and other cases that are, you know, they're reaching the court or they're reaching settlements earlier. What's your feel about the approach? I mean, are we seeing any difference in approach on prosecution?
It was taking too long before the pandemic. It's now taking even longer still. So if I give you a couple of examples, you'll know about the Didcot fatalities. There is no suggestion at all that that may be going any further anytime soon. It certainly hasn't gone away, and it just lies in the system. But delays, I think, are difficult for those involved, and they're difficult for the process. People's memories fade, and there is a point where when these cases get to court so long after the event, the bit that's often perhaps forgotten about is the effect that it's actually had on the businesses and the clients as well. So these are hanging over, in some instances, 6 and more years, where individuals are worried about their own liberty, the ongoing viability of the business, and then a fine at the end of it, let alone the PR. And going back to what you said before, of course, most businesses where they have an ongoing case, there's usually some form of obligation to disclose that in tenders or in annual reports, etc. So you're almost damned even before you've had a trial on these. So at the end of the day, if you're acquitted, that's the bit that nobody ever remembers because they're never reported.
Absolutely, and I think we've both seen, companies that have really struggled in that. And obviously, the point you picked up earlier on the financial, you've got investors who are now more conscious about reputational risk in relation to health and safety in the same way as they are for environmental. You see this more and more with pension funds, for example, who have offering ethical shares, company shares. So they're going to be very, very mindful of the impact. So I suppose really, we talk about what the regulator does and what the courts will do, but actually in reality, the impact to a business is coming from 3 or 4 different angles, to be fair, I guess.
It is, and we know, because we know how it works, don't we, that if a business of a certain size came out of court with a fine of, I don't know, £200,000, most people in the field would understand that is saying that it's a very low culpability matter, not the worst breach in the world, and yet still the headline fine is still quite substantial, isn't it? At the opposite end of the spectrum, we've seen a couple of cases since last year, and just to give you an idea as to where the mood music is going on all of this, we think a fine of £6.5 million for a company called WH Malcolm. That, I think, from memory, is the biggest fine there has been for about 20 years in this field since the rail crashes. Just, I think, within the last month or two, Northern Power Networks, that I think was a £5 million fine. And then, of course, with my environmental hat on, we'll all know about Southern Water with the 90 million fine. So the power is still out there. And this is actually coinciding with a time when there are fewer prosecutions, so the likelihood of you going to court might be less, but the consequences, if you are that unfortunate company that's taken to court, are higher. The average figure's gone up by about another £40,000. So I guess really from our perspective, it's trying to advise clients really early on what sort of cases will go to court and which ones won't. But I think what we're seeing is a common theme here, perhaps a smaller number of cases, but those which are actually taken forward, a much greater interest taken by the regulators, a huge investment of time and cost. And then, of course, if they just get a bit of an interest in the case early on, sometimes they build up a bit of momentum there, and it can be quite difficult to shake them off. Just to put a bit of flesh on the bones on that in terms of numbers, you asked about the delays caused by the pandemic. There was already a huge backlog in the criminal justice system even before the pandemic. Dominic Raab, bless him, was very pleased to report that he'd cut the number of cases by 2,000 within about the last couple of weeks. But if I tell you that he's cut it from 61,000 to 59,000, then that still, I think, gives you an idea as to where the system's going. What does that mean in practice? Only the most serious cases are going to be making it to court. But I think going even further back in the timeline, I think this is something that we're seeing regulators pay more attention to much earlier on in the case. So, for example, I have guarding incidents where some very, very serious amputations there, 3 and 2 fingers, which perhaps in bygone times you might have thought would be a cast iron certain HSE prosecution. If I tell you that these are sizable businesses that I'm representing, in some instances the HSE have had the Riddle report and never even contacted anybody. Now that isn't a change in their enforcement policy, far from it. I think that simply just reflects where we're at and the resources that they've got now. So if they went to court 4 years from now, and as a result of that, the rapists and the burglars and the muggers cases were put further back in the queue, how would the criminal justice system react to that? Well, they're all serious, but you can sort of see why our cases perhaps are at the back of the queue at the moment.
Do you think then, I mean, obviously there's alternative resolution opportunities. Do you think a lot of these cases are going to end up becoming settled prior to them going through the court doors then?
We've seen a lot of that. We've got an alternative case disposal procedure whereby both prosecutor and defendant are now under a duty, there's guidance that was issued at the height of the pandemic, to factor in exactly what you've just said. You know, is this one of the most serious cases? Does it really need to leapfrog the existing backlogs? And is it one that really needs to go to court at all? So what we've seen a lot of experience of is negotiations with prosecutors. Often they don't take the case at all. Sometimes, particularly with local authority prosecutors, it can be downgraded to a formal caution. Sometimes you'll pay their costs and you'll get a fairly sharply worded letter warning you as to your future conduct. But the general point is there are now far more options open to regulators, and they are encouraged to look at them. You know, we're told not to clog up the court systems any further. So again, in terms of figures, over the last year, the number of prosecutions is now down for the first time ever since I've been practicing to below 200. I think that was about 650 5 or 6 years ago, and that figure is down about 40% or more even on last year's figure. So you see a general direction of travel there. Whether or not that will be sustained, well, probably depends on events in the world, and hopefully that there aren't too many serious incidents. Now, that may or may not be accounted for by COVID. While people are working from home, they're less likely to have accidents. The economic activity, as we saw, just ground to a halt. And in the road traffic context, of course, nobody was driving around really. That, I think, was the past, and we're coming out of it. But I think we're almost still left with more of a focus on what it is you're hoping to achieve by prosecuting. So yes, you're right. I think there are greater public interest arguments about prosecuting certain companies at this moment in time than ever there have been. And even on those ongoing cases that have already gone on for 3 or 4 years, what we're seeing is HSE being a little bit more pragmatic than ever they were. So, for example, they might agree that the culpability level is lower. They might not actually disclose all of their evidence for expediency. They might just want the case to go through court and to get a conviction. So we don't do deals within the health and safety sphere, but certainly there are negotiations to be had at this moment.
Yeah, so I think I mean, you're right. It's one of those situations where it's ever going to be evolving, and policy at some point, policy will come through from HSE, I guess, that sort of directs inspectors to take a view on what level they're going to try and do a resolution before it goes to court. But I guess anything where there's a strong possibility of someone being incarcerated as a result of an incident, death in the workplace, is still a real and possible danger for any employer, isn't it?
It really is. It makes it difficult. I'm not expecting a huge sympathy for the defence advocate here, but it does make it quite difficult to advise clients, because at one end of the spectrum, you could see exactly the same circumstances in the same accident and say to them, well, there is a 50% chance you will never hear a thing about this. Put it right and move on, and redouble your efforts to ensure safety. The opposite end of the spectrum, it may turn into one of these cases where 4 or 5 years after the event, we're having a trial with the risk of the turnover and everything that we've said. So there's no great certainty at the moment. I think it really just reflects, as I say, the practical situation on the ground.
Yeah, I mean, I think like everything else in the workplace, we're now talking about, you know, a new environment, a new way of working, and new risks. I know previously HSE were very much focused on specific industries. Pre-pandemic, you knew there were certain industries that unfortunately were going to be in the crosshairs of an HSE inspector for either a spot visit or some more structured intervention. the high risk industries that we know about, the sort of top tier coma sites, the construction sites and things like that. And I guess really what COVID has done, one of the many things it's done, is it's made people have to reevaluate what their priorities are and where they're going to be working. And I think HSE were given a pretty difficult job back in 2020 in relation to COVID management. And they sort of, I think they got bogged down with a lot of that. So it would be interesting to see, when they look at their next, because I think their 5-year strategy is due for 2023, if memory serves. So they're going to be looking at what their enforcement activity is going to be focused on. And it's going to be difficult because they've effectively lost 2 years worth of data. We've got riddle reporting that was required for COVID in the early days, which frankly just became a bit of a mess. So when you're looking at your sort of statistical analysis of where do you focus your attention and resources on, I guess it's a tough one to go to. So you do that default position. Well, don't get in the crosshairs. Focus on your good quality health and safety. And as I opened earlier on, the reputational damage argument probably has just as much weight as the regulator argument at the moment, isn't it? Really.
I think it does. I'll be quite honest with you. There is a certain category of case for a certain category of client where the nature of what you're facing, the publicity is one of the strategic factors and not just the fine. So, for example, you might go along to a magistrate's court ready just to go not guilty and set the whole thing down for a trial 2 or 3 years from now. But if you're the only person there, there's no media, there's no reporters, and nobody's going to be interested in the outcome, or it's another news day with something else that's going to hit the headlines. You do see these days in a lot of these cases that the media people from the company are sort of begging me just to get the thing finished and out with no publicity. So you're right, that's the way it's going. One thing just to flag based on what you've said there, the occupational health agenda hasn't gone away. And even though perhaps they were enforcing it less for obvious reasons over the last couple of years, we do still definitely see a shift back to that. So that's still where they want to go with it. And I think perhaps in some of the larger corporate clients that we act for, I feel sometimes that the discretion that's given by the inspectors is less because their expectation with the higher turnover is that they're able to devote more time and urgency to it. So we've seen in general terms, not only a reduction in prosecutions, but the number of notices being served has reduced as well. The trend seems to be these days more towards these notification of contraventions, where, as you know, you're charged under the fee for intervention scheme where there's a material breach. But again, during COVID, you had a little bit more time even than normal to really go down the mine and analyse the wording of some of these notices. An awful lot of them were challengeable. And I can certainly recount a few cases where HSE had almost sort of stocked up quite a considerable amount of cost on their part. But if they've not actually served it in accordance with a compliant notice, I'm afraid on a few occasions we were saying, sorry, there's nothing due. So you've really got to, I think, be very quick to respond to these. Headline where you think a case could go to, hope for the best, but be absolutely prepared that it might go in a different direction. As a natural born optimist, I think the two things, the only perhaps positives out of COVID, you do tend to see people on the shop floor perhaps a little bit more understanding and appreciative of why these rules exist and perhaps complying with safety rules more than they ever did. And I think at board level, I've had more queries to go and speak to them about health and safety, and they now value, which is great for those on the call, the input and the hard work and the efforts of the health and safety practitioners, and sort of understand how it works a bit more. So it's a more nuanced message these days. Historically, it would have been in part, well, look what happens when it goes horribly wrong. These days, I do see that some boards are just genuinely more interested on a personal level. So there's always a positive if you look hard enough.
I think you're absolutely right. And my own experience when we've been auditing is exactly that. The common theme is coming through more and more now that organisations have recognised that health and safety practitioners have been a real godsend for most of them during a pandemic, because they needed people who could help them navigate through the legislative requirements and the practical applications. So, you know, it's an awful thing to sort of take a good out of a pretty horrendous 2 years. But I would say in my career, this is probably the ascendancy for practitioners. Good practical practitioners out there are finding that their voices are being heard, which is brilliant. You know, long may it continue. But we are in a position where we're fundamental to we're now fundamental to the rebuilding of businesses. You know, because they're trying to get back onto an even keel in very, very difficult circumstances. So, you know, it's an opportunity for a lot of health and safety people out there.
Yes, they've got the trust of the board, they've got the ear of the board, and I think they are more able to influence board than ever they did before. And of course, the other benefit to that perhaps is we've seen that demand for people in the profession is probably higher than ever it's been as well. So there's another benefit that comes out of it again.
Are there any other legal sort of court specific cases that you feel was worth sharing at this stage, Chris?
Sure. We saw one where this age-old issue since the sentencing guidelines between a large organisation and a very large organisation, you can see that hasn't really gone away. And sometimes in this field, those who practice in both will know that environmental sentencing sometimes sets the trend and then health and safety sort of follow on its coattails. What we've seen is examples where you almost know a very large organisation when you see one, and there's certainly been comments to suggest that there should be a figure, a definition of where that kicks in turnover terms. Everybody's resisted that so far, and I don't know of any judgment where they've said a very large organisation is at a certain level. But if I tell you that in one case, a business of 250 million was deemed to be a very large organisation, then there'll be a few people on the call sitting up and taking notice. So when we're taking that back to the board and we're saying to them what the level of fine could be, that's of a higher magnitude now than ever it's been. In terms of case law, look out for anybody that's interested in the technical detail. Every time we do an update, there usually seems to be a change in the law on legal professional privilege, and not to disappoint, there has been one during the course of this year, and that touches on correspondence between you, your lawyer, and experts. There was an attempt made to suggest that a document wasn't actually confidential. We all know why that's important to make sure that they are as part of your accident investigation procedure. So again, be clear whether documents are in fact legally privileged, and keep a weather eye on some of these cases that go through the courts, because there is a general idea, I think, in some judgments where they're trying to restrict the effect of that concept as long as they possibly can. In terms of other cases, as I say, we've had the Northern Networks and the Malcolm case as well, with some of the high figures. I've got to be very careful about the next one because I'm very limited about what I can say about it. You may have seen a case called Alutrade reported recently. Again, that goes back to a fatality about 3 or 4 years ago, where the outcome was a corporate manslaughter with a fine of £2 million. That's about all I can say because that's in the public domain for reasons that will probably be obvious. But I think that spins out really into the general landscape ahead and horizon scanning. What we're seeing really is sometimes after the event, there will be an inquest, and there will usually be a family these days trying to make the law go further than it currently does. They'll identify a gap in the legislation. So the classic one that everybody knows about, which again has really highlighted the importance of safety at board level, is Natasha's Law. So you will now go into any food stall, sandwich bar, whatever, and you'll see the labelling is totally different. A slightly different angle, but those in the food industry will know we've now got calories listed on any food menus as well. You'll have all seen the Manchester Arena inquiry following the attack in 2017. Again, I'm pretty limited in what I can say about all of that, but in terms of driving forward changes in the law, Martin's Law is dedicated to one of the victims of the attack. And the idea there is that public premises of a certain size are going to be put under a duty to look at safety insofar as security and terrorism is concerned. So there is a duty to protect that we think might come onto the statute books. And each and every time I'm in front of a coroner these days, this prevention of future deaths power that he or she has got is interpreted quite widely. So the media may report what may have been possible, and there may be a whole host of things that didn't relate to the incident, wouldn't have made any difference, that in theory are physically feasible. And you'll get coroners occasionally looking in quite wide detail about whether there is anything more that big business can do. So that's a bit of a trend. And it puts you in a bit of a difficult position because the law is what it says, and there are requirements to only do what is reasonable, not everything possible. But that message sometimes gets a little bit lost in the telling, I'm afraid. So in general terms, that I think is more likely to inform any changes in the law, post-incident. We know about Grenfell, obviously. We've now got, as of last week, the Building Safety Act is finally on the statute book with royal assent. Just skipping through that very briefly, I don't know how many people on the call are affected by that, but if you've got the high risk buildings of 7 stories or 18 metres, there's particular rules and a new enforcement regime for that. General duties in terms of multi-occupied premises to extend to the cladding in the entire building, and a compensation type scheme there to look over buildings that have been constructed over the last few years, and whether or not there's any cladding repairs that need to be done at your expense. So those really sort of building safety on the back of the fire safety changes are probably about the main legislative changes that we've seen. Just into the category of under the radar, people on the call may or may not have noticed the change to the PPE regulations. You'll know that previously, broadly, you only had to supply that to employees. Well, that's widened now into a curious concept that's taken from EU law, where really I think to rely on who's your employee and who isn't, by the end of it, for commercial expediency, you might just be better making PPE available to everybody.
Right. Even the wording of it, it sort of it has a caveat at the end, which if anybody's actually read it, is in a very macabre way quite amusing, because it sort of says, well, if you're not sure, then a court or tribunal will make a decision for you, which sort of feels like if you want to have a go, but then a court might decide something completely different. So you're right. I think for expediency's sake, it's better to say, you know what, I want to make sure as an employer, direct employer, or through a third party, that individual or those individuals have the right PPE to do the job, whether they're your employees or not. You need to be proactive to it and show that you're being proactive, and it will, like all these things, it will end up being tested in court, and none of us ever want to be that person in the dock having to defend it and waiting for a court or a tribunal to make a judgment on how they define it. So it is, it's a conversation I've had with many people, and they've all scratched their heads and reread it 15 times and still haven't come up with a solution how they can interpret it.
I think that's right, and I guess the main difference in some of the legislative changes going forward is that they're more explicit in some specific requirement than they were before. But arguably, as a former prosecutor, you might say that they only really confirm what the law was previously, because if you didn't actually take the step that's now being expressly required of you, then usually you'd fallen foul of a general duty anyway. but perhaps people in my industry have been guilty of taking too many loopholes over some of these cases, if you can be. And for that reason, at least clarity is king, isn't it? It's good to have legislation where everybody knows exactly what's expected of them. So again, you're looking in the context of fire safety, aren't you? And the guidance that's to be issued, that will in effect give you some confidence that you're legally compliant. But again, there's still going to be grey areas, and it's still very much a new area of the law. In very general terms, there's not an awful lot of themes to this over the last year. We've been trying to see if there's any sort of a strategic hook we can hang any of this on, and it's actually just disparate changes to the law. We now have the causing serious injury by careless driving on the roads for those of you that have occupational road risk duties. That's been perceived to be a gap for several years. That's only just come into force. We've now got guidance issued by the HSE on grey fleet and occupational road risk. We know that the first big company where there is any link beyond the driving that's caused the accident and the corporate business can probably expect little change from the health and safety executive. They're really just waiting for the first call or first case that comes through of that ilk. There are disclosure requirements for certain big companies in relation to climate. I'm straying more into environment now. And we know that despite various protestations to the contrary, then red diesel isn't going to be permitted on certain construction vehicles as well. So it really is the perfect storm at the moment, isn't it? And I do have some sympathy for those on the call. Just after you've got through turnover fines and occupational road risks, you then go into the pandemic, you've then got the pingdemic, you've then got supply chains and Brexit, and now the Ukraine issues as well. So I dare say some people have taken on wider risk roles throughout the pandemic, and they're probably now looking at supply chains and seeing whether there's anything to do with Russia or the Ukraine. Never stops really, does it?
It's an ever-changing environment to work in. Just quickly going back to the Building Safety Act, obviously that's predominantly the major piece of legislation that we've had coming on the statute books and being enacted. And obviously, a lot of people may be aware of the journey this particular legislation's taken over the years since Grenfell. And there's been a lot of conversation and probably a bit of trading, I would guess, between certain sectors in the building industry. I think one of the biggest things that I think we've seen coming out of this is the fact that HSE have been tasked with regulating this particular area, which in all honesty seems a bit surprising considering they've had resource issues for many years now. And take on this, that's a big ask, and to get the necessary skill set of people to be able to be the regulator of this, I think is going to be a really big ask. I mean, and I'm putting you on the spot on this, Chris. Where do you see this actually going in relation to enforcement activity? Because we all know that there's a lot of situations that have come up where claddings had to be replaced, extra fire watches put in place, all sorts of impacts, financial impacts. Do you see the regulator actually being able to undertake their duties in any reasonable timescale? Say before the end of the year, are they going to have the resources to make this happen? Because I see this as a really big challenge, because the people they need to do this, they're not easy to come by, and they need to train people up to have the necessary skills to be able to be effective regulators in this area.
Well, I think that's absolutely right, and they're hoping that the profile that this has had over the last few years means that duty holders will understand this. They're perhaps more clued up on what's required of them than ever they were before. So I think very much the impression I take is that they're hoping that industry will regulate itself. And I suspect what'll drive it going forward, I'm afraid, is the public perception and the understanding of what developers and the likes and accountable persons are required to do now is at a level it's never been before. So I think the short answer is I'm not sure regulators will be out carrying out routine sort of random inspections, but I think wherever there is a serious case where after the first 3 or 4 letters trying to nudge from the residents association or people in a tower block that isn't compliant, I think there's going to come a point where businesses just can't ignore that and look at the profile of it and how Grenfell evolved. It would be a brave developer, anybody in that field, that ignored this. I suspect, again, perhaps the more negative view, somebody that prosecuted a few fire safety cases in his time, the difficulty you get in practice is still going to be who's responsible for what, because albeit this is a lot clearer now, and it almost ensures dual duties, doesn't it, across the piece, it's still likely to need what you've always wanted, which is people getting around a table, thrashing it out and just agreeing that somebody's going to do it. So there's still the scope for things to fall into the gaps and responsibilities to fall between the two, but far, far less than ever there was. I think you'll find that people who are affected by this, who think they may, heaven forbid, end up in a risky premises, just won't let this go anymore. So a complaint that goes to a regulator, they'll almost have no discretion. They'll have to go in and they'll have to start serving notices. You'll know that that's another new part of the Act, which came in almost quite late in the day, actually. So again, if people have missed this, remediation orders are now part of the Act, so that you can force landlords to actually remedy defects. So you'd be interested to see how that one pans out, both in terms of any civil claims or direct action, and even if you don't force them to do the work directly, then you can get a recharge power, so that you can go in and pretty much do the work and get them to pay for it as well. So that is a big step forward, and yet ironically, you started the question with how it all works in HSE terms. Of course, right at the end of the legislative process, the idea of the building safety manager seems to have vanished and been scrapped from the proposal.
That was surprising, wasn't it?
It was, and again, you sort of wonder whether that's going to allow people to suggest that it wasn't clear as between them, but woe betide anybody that would volunteer for the role of the building safety manager. I suspect that might have played a part in the thinking.
Yeah, absolutely. Well, we'll just have to see it. Like everything else, it's a new and emerging world. I guess really one of the things, just mindful of the time, we need to touch on, and I think that's the new world of work post-pandemic. There's been lots and lots of talk about hybrid working. Personally, I think we're still in a testing situation. Nobody really knows what hybrid really looks like. And HSE have been quite noticeable by their silence in relation to employers' responsibilities. And I know a lot of organisations they've been very practical. And to be fair, I think, something you mentioned earlier on, and it's a strong belief of mine that industry sort of works out a solution before the HSE gets to them, because they need, from a practical point of view, they need to work out a solution. And there is already requirements and regulations on statute that we're obliged to follow anyway. So although the question mark around what hybrid working looks like, I guess really the obligations aren't really going to change massively anyway. Providing people who are working from home with a suitable workstation. Now, I have a suitable workstation at home. Would I expect my employer to come round and check it for me? Well, not really, because this is my home. And people may still be working off their kitchen tables, hopefully not now, but we're in a position where there's that constant need to be actively involving practitioners in making sure that everything that's reasonable has been done. I know there was a case, some people may have seen it, of a German court that made a decision on an accident from an employee working at home. And they they said that the employer had a liability, an insurance liability, because the person was still at work. Now, thankfully, the UK, we don't have that. And I guess really, from a legal perspective, it's unlikely that that would get very far in a civil case. But the question is always going to be, are you doing everything you possibly can for your employees, isn't it, for those people who are working from home?
I think that's right. I think this one almost rests on that good old concept of common sense and flexibility. I remember getting a number of queries on this right at the start of the pandemic, when people were just grabbing the first screen they could out of the office and taking it home, and you didn't have suitable seats and anything that was posture related or adapted for the purpose. Things have moved on, I think, and forgive me, I'm not an HR lawyer, but speaking to people who are, there is a really easy answer to some of those queries, and certain businesses have pointed out that rather than having queries for screens to be set up in a certain way and footrests and all the rest of it, an easy way around that would actually just be to say to the employee, well, if you can't satisfy us that it's safe, then you're coming back to work full time. And I don't know of one example where that hasn't actually worked going forward. Now, that's not the full answer, is it? Because people, I think, just recognise the shift in people's attitudes and how valuable the hybrid working scheme is and the flexibility that it's given to people. But in strict legal terms, most contracts, certainly if they're pre-pandemic, do actually have the right to insist that you go back to work full time. I don't know of anybody really that's done that in any great numbers. We haven't. I'm talking to you from home. But
I think the majority of people that I've been dealing with over the last 2 years have been looking hybrid, finding a system that works. Because I guess it sort of feels really quite, I mean, obviously it's a seismic change. You know, we're looking at things that happened pre the Industrial Revolution, but with technology. You know, people are working from home in the days that people used to work from home before factories came into play. So it is quite a seismic change. We've changed as a society anyway. Our culture, our safety culture is different than it was back then, obviously. But we're looking at finding solutions that work for both the company or the employer and the employee, which is quite a novel approach in anyone's perspective, because that's not necessarily what businesses have historically done. It's okay, what works for the business, and then if it happens to work for the employee, then great. But the primary aim is what works for the business. And something that we discussed earlier on in our conversation is, you know, the effect that boards have now recognised the impact of well-being. Well, actually, this is part of that well-being conversation. You know, is it better for the individual to be working from home? Does their work-life balance work better? Is it better for the individual to actually work in the office because, or you know, in the workplace generally, because there's a need for that because the business is opening up, or is it a need for that individual because they actually don't really work very well when they're on their own? So, you know, there's a multitude of solutions, but I think the only thing I would say with a relative comment, I'm 90% certain, is what's coming out of this is more meaningful conversations and finding solutions. And I guess what hybrid is going to look like, I don't think you can honestly say that there's going to be a one-size-fits-all. There's going to be hundreds, thousands of different ways of looking at it, because it's going to be very unique to the business, to the employee, to the employer.
It is, and yeah, it's very much a wait and see, isn't it? But the general proposition of flexibility and not having to be located as close to the office, there are real benefits to a lot of businesses to that. You can get a much bigger pool of talent, and if you really ask yourself the question, do we need to be in the office full time? Usually the answer is no. We've been doing a lot of the court hearings remotely. That's to sort of varying or lesser degrees successful, but that's got a lot better. But it's these days, the first question, do I actually need to be doing this meeting in person? And usually the answer is no. It's the same with a mobile phone test, isn't it? Do I need to be taking this call? Do I need to have the mobile phone in the car at all? Usually no, but you've got to go through a process to actually establish that, haven't you?
Yeah. Okay, well, thanks, Chris. Elaine's popped up, which means we must have been talking far longer than we anticipated doing. So thank you, Chris.
Yeah, thanks, Chris and Phil, for such an interesting and broad-reaching discussion. We're now at 11:54, so we'd like to turn it over to all the attendees. If you have any questions for Phil and Chris, if you just pop them in the chat area, we'd be happy to answer them for you.
Yeah, I should say apologies. When we do webinars that don't have technical glitches, as this morning, I can usually see chat and see whether there's any questions come up, but if there are any, I haven't seen them to date.
Sorry, I can't see anybody who's popped a question in, so please don't be shy. Do put a question in there. Take advantage of the opportunity to ask our panel experts.
I think my question, Elaine, would be how do I get the webcam to work? But sadly, I don't think that's going to happen during the course of the
I know
session.
the answer to that one, Chris. Talk to the IT department.
But yeah, I couldn't see you, but at least I can hear you, and we're halfway there, and it's been a good chat.
We'll have it fixed for the next time round, for sure.
Fantastic.
Well, hopefully you have got something out of this conversation, and please, if you do have anything that you want to feedback on the format of this, we'd be very grateful to hear it. I know we do have a lot of times these sort of things are presenter based, but we felt that a conversation was a little bit more meaningful for people, so it'd be good to hear what people feel about that.
Sure. Actually, that's the other thing I should just say, Phil. We often get on these sessions a particular query that's across somebody's desk that they would rather perhaps not share in the open forum. We'll stay on for a little bit afterwards, or if not, then it's Chris Green at Keogh's if anybody's got any queries. But if not, I hope you've got something out of that.
And if anybody does want to submit a question to events@britsec.org, please do so also. We'll pass that on to Chris and Phil. That's no problem at all if you don't want to post it in the chat area. But we have recorded this webinar. We'll be posting it on the members area of the website. So please do, if you want to pass it on to colleagues, please do so. But I think unless we see any question in the next 30 seconds, we'll draw this webinar to a close.
Super, thanks everyone. Good to speak.
Yeah, thanks everyone. Have a good rest today. Thank you for attending today.
Bye-bye.